So I'm Marcie Jones. I am a certified land use nerd, self-certified. I'm an attorney with the Office of the Property Rights Ombudsman, greatest job ever. And before I went to law school, I was a planner. Also a great job, but I get yelled at a lot less in my current position. But I love the way land is used and the rules around it and sort of the conflicts between constitutional property rights and what's in the best interest of the community at large. I love this stuff. So I'll do the bulk of the presenting here today, but we also have Rob Terry, who's with our office. He's a statewide land use training coordinator. He'll jump in and correct me or add things. We also have Rick Plen, who's another attorney with our office. And this is intended to be like a conversation, so at any point you have questions, you have comments, you want more clarification, raise your hand. I'd like to start with kind of, so you know who I am. Who here is like planning staff? Okay, who is like planning commissioner or city council? Okay, and then anyone else? Tell me who the else's are. Students? No. Oh, nice, okay. Nice, okay. Nice try. Yeah, it's nice to see familiar faces. Okay, so the Office of the Property Rights Ombudsman, we really quick, we have two main areas of expertise. Our office is created by the state coming up on 30 years ago. We are charged with being experts in eminent domain and land use regulations. Those are the two things we know a ton about. Eminent domain could be takings, like you're acquiring land for a park or to widen your roadway. It could be you're accidentally, you built your cell phone towers on someone else's property and you've got to sort it out, or you built your sidewalk on someone else's property. And then land use regulations is really what we're here to talk about today. And anything from impact fees, land use applications, certificates of occupancy, variances, impact fees. I got that up there twice. I guess it's on my mind lately. Legal non-conforming uses. But so we know a ton about those two topics. How do we help? So with eminent domain, the biggest thing we do is we mediate. We give folks a forum to resolve the dispute. So if you're trying to acquire a property and you're trying to stay out of court, I mean, first of all, if you're acquiring property, you're obligated to tell them about our office and what their rights are. But we're here as a neutral third party to help you resolve the dispute. We can get a second appraisal, because usually the dispute is still about value. Because if you need it for a valid public purpose, 100% of the time you're gonna get it. It's really just how much you're gonna pay. And then how can we help with land use regulations? Advisory opinions or written opinions. Cities ask for them, cities, towns, counties, property owners, neighbors, they can ask, they can say, hey, is this impact fee legal? Should this subdivision plat be approved? This is what the ordinance says. Are we interpreting it correctly? So we issue advisory opinions. We answer tons of questions, like 1,500 calls a year on calls not associated with files we've opened. We do lots of education. We've got a great website. We do training seminars. And now, as of the last 3 years, we have Rob Terry, who's the statewide land use training director, and he's put together some incredible resources. You probably already know about that, or I'll let him talk about that another time. But like, you need training, you need to know about stuff, you reach out. If it's land use related, we should be able to help you. And then he also administers land use training fund. Okay, so what are we doing here today? We're talking about familiar but forbidden. Why do we want to talk about this? Avoiding lawsuits can be fun, right? And knowing how to do your job well, I think, is really rewarding. I know when I was a planner, that's part of why I went to law school, is I wanted to understand, how do these overlapping laws work, or how do constitutional rights work with ordinances, things like that. So I'm going to start off with property rights and sort of the underlying theme, or sort of the underlying basis that informs the laws we're going to talk about next. So the property rights are protected by the Utah Constitution. Article 1, Section 1 begins, all persons have the inherent and inalienable right to acquire, possess, and protect property. I would say without being spoken that the ability to use land is also in there. So it's how we start. No person shall be deprived of property without due process of law. Private property shall not be taken or damaged for public use without just compensation. And all laws of general nature shall have uniform operation. And in this instance, that means if you've got a zoning ordinance, you need to apply it to everybody. But this sort of informs my thinking, or informs the court's thinking if they're having to review decisions you've made. And we balance those private property rights with the government's inherent police power, the authority to regulate for the health, safety, morals, and general welfare of the public. So a lot of what we end up talking about in land use is sort of the intersection of those two ideals, the property rights and just sort of that inherent ability to use your land toward productive use, and then also it can be at odds is the needs of the community and the government's ability or interest to regulate what you do with your land. So I'm going to start off with sort of some broad ideas that govern decisions generally, and then I'm going to hit on specific things in state law that the state legislatures have decided to regulate. They've decided to put either a floor or a ceiling on what you can do. So the first thing I want to talk about just is sort of a continuation of that constitutional conversation, that applicants have the right to use their property in any way not plainly restricted by law. A lot of times, I feel like cities think, or neighbors, angry neighbors think, when an applicant comes in, well, let's have a reasonable conversation about what is the best use of the land. And that's not actually the way that conversation, I mean, there's a place for that conversation, but once you have a land use application before you, or you're evaluating whether or not someone can do something with their land, the law says the applicant has the right to use their property in any way that's not plainly restricted. So if they want to have a dump and they want to have outdoor theater seating, they can, if you don't plainly outlaw it. The second thing that sort of governs the approach to evaluating is something legal or not is approval is required. You must approve an administrative application that complies the applicable land use regulations. It's the flip side of if you don't say no, then you have to say yes. There's exceptions for variances, and amended plats would include some discretion. But otherwise, if it's an administrative application, you have to say yes. It's a checklist. And if they can check every box, the answer is yes. The next thing that comes up is vested rights. And I don't know why it's called. I guess you're vested in it. It just seems like a kind of a crazy way to talk. But vested rights, the applicant has the right to use their land, to have their land use application reviewed under the land use regulations in effect the day that they submit their complete application. Utah has really early vesting laws. There are other communities, other states, other cities where the rules, the ordinances can be changed even after they start building. So there's some places that even up until almost that you get the certificate of occupancy, that the city, and I'm going to say city generically, city, planning and government here at the local and municipal county level. So city means city, town, county. I'm including it all. But there are other communities that would allow you to limit, say, the height of a building or change the setback even after they start building out of the ground. Utah really favors private property rights. In Utah, once you submit a complete application, and it doesn't have to be a perfect application, it has to include all the components that you've asked for. But if it includes all the components you've asked for, even if you redline things and have to send it back and get, changes made so the grading plan or the engineering or the easement meets code, as long as the components are there, including paying for it, those are the rules that you apply to that application. We're going to talk about, there's 2 exceptions to that. We're going to talk about it later because I really want to go into the distinctions between what they are. But by and large, you don't get another bite at the apple. You have broad discretion to decide what your rules are going to be before that application comes in. But once that application comes in, you apply the rules that are in place. Yeah, saying the same thing. You can't change the rules. Once you get an application, you can't change the rules. And I'll add too that if you're silent on something, you don't regulate it, and that you are not regulating it, and it means that they can do it. We were doing a training down in Richfield on Tuesday, and there's several very, very, very small communities in that area. And one was saying that they had an application for a 600-gallon propane tank as part of a business, and that they didn't regulate it at all, and neighbors were really concerned. And I said, well, I mean, if you don't have anything in place when they apply, they get to do whatever they want. I mean, that's like period. If it's a commercial zone and you have setbacks, it'll be subject to setbacks or landscaping or parking, things like that. But if you don't regulate it, it's allowed. And short-term rentals, that's another one. I feel like that's been around long enough that people have figured out they need some sort of short-term rental ordinance. But if you aren't regulating short-term rentals and people begin that use, they have a legal non-conforming use that can continue. You aren't regulating it. Okay, any ambiguity. This one's really important, or it comes up a lot. You can only require what's clearly stated in your ordinance, law, or regulation. Any ambiguity is interpreted in favor of allowing the proposed use. So you might have, it's not uncommon that codes are adopted in pieces or under different councils or different planning commissions. So you might have one thing that's addressed in one section and then addressed again in another section. Whichever one is more lenient is what's going to apply. And it's whatever, if there's a reasonable interpretation that would allow the use, you've got to allow it, which, I mean, is tricky, but it's true. And it goes back to that people have a constitutional right to use their property, and the common law status is that they can do whatever they want unless they have notice ahead of time that they couldn't. Okay, one of the things we look at, well, I want to back up. I keep talking about property rights, and I haven't talked much about the other side of things, of the government's general police power to regulate for the health, safety, welfare, and morals, although morals typically gets dropped off for the last 50 years or so. When you're creating ordinances, when you're deciding what the rule should be, you're given broad discretion to determine what it is. Does anyone have a guess on how many times a court has overturned a law in Utah that was passed by, town, county, city council, that was, properly passed, like it went through the proper notification and meetings and things like that? How many times has the court overturned a law? Zero, exactly zero. The court is going to support the government's right to determine what's in the best interest of your community, as long as it doesn't violate state law. So 100% of those laws that you pass, the court is going to uphold. That is both because they want the cities, towns, counties to be the decision makers. They want, they believe you do know what's in the best interest of your communities, and they want for there to be local accountability. So you can vote new politicians in if you disagree with what they say. And that way too, it's more immediate results. If you have to appeal a decision to court and it gets appealed to appellate court and goes up to the Utah Supreme Court, well, you're hundreds of thousands of dollars in and several years later, and you've got judges that are making decisions that are very far removed from your community. So the government has broad powers when creating the laws. It's really when applying the law that pendulum sort of switches back, and It's a lot more prescribed. So you can pass any law that's not illegal. And so illegal, does it violate any federal laws? Freedom of speech is a big one. Federal law doesn't touch on land use a ton, but freedom of speech, so like signs, flags, I think that'll be kind of an interesting thing to watch go through the courts maybe. Religious practice and group homes, those are sort of the areas that the federal government has decided to step in. Does the state put bounds on it? Gravel pits, billboards, internal accessory dwelling units. The rest of the slides after this are all going to talk about instances where the state has basically preempted your rights. But does the state regulate it? And then is it regulated in another ordinance? It's not that uncommon to have ordinances self-contradict, just because we're all human, or they're passed in pieces. So if you're asking whether it's illegal, that's kind of the thought process, or those are sort of the red flags I look for. And this is really the last sort of overarching principle is this legal non-conforming use. And I mentioned this earlier in if you're not regulating something, that it means you're allowing it. But a legal non-conforming use is a use of land that was established at a time when the use was legal and that it has continued, but has become illegal because of a subsequent change in the land use regulations governing the land. So people often will call this being grandfathered. And legal non-conforming uses, generally they can continue unless they're abandoned. And abandoned usually means a year of non-use or not trying to use. So like say you had a restaurant that had been open and then COVID shut it down, and they were looking for new tenants or trying to open, but they weren't open for a year. I would say that isn't abandoned. It has to actually be non-used for a year. So if it started, and if it started before it was regulated, it can continue, and it can continue in perpetuity. I've gotten several calls about short-term rentals that way. If someone started a short-term rental 10 years ago before anyone thought it was a problem, that home can continue to be a short-term rental, forever. Okay. Conditional use permits. Who went to conditional use permit last hour? Okay, so a lot of people have heard about this. I just got the second half, so I'm not sure what's a repeat and what's not. But I think conditional use permits, and I haven't counted, so this is just me being a land use nerd, this is the most litigated land use application. It lends itself to people fighting and misunderstanding, whether it's angry neighbors thinking that they have a say, or whoever's making the decision imposing conditions that they shouldn't. But conditional uses are a yes. It's not when you say, okay, well, permitted uses are a yes, and not permitted uses are a no, prohibited uses are a no, conditional uses are a maybe. That's not the way state law is written. State law is a conditional use permit is a yes, as long as you can impose reasonable conditions that offset the reasonably anticipated detrimental effects of the proposed use. You don't have to eliminate the expected detrimental effects. You just have to be able to mitigate them. And I'd have a hard time not thinking of something some condition that could mitigate just about anything. Light. Well, they can, put lighting that's downward facing or on the other side. Well, how about parking? They can add parking. How about noise? Well, you can add a landscape buffer or an opaque solid wall. The vast majority of things you can propose conditions that could mitigate it. So I would just be careful when you create conditional uses to know that you're really saying yes. And it's got to, if you're imposing conditions, it's got to be in accordance with objective standards that are stated in your local ordinance, or ideally they're stated in your local ordinance. If you're imposing conditions that you don't contemplate in your ordinance, I think you're asking for trouble. I'm not saying you can't, but like I use dog kennels as a common example. If you say dog kennels are a conditional use, and you can look at parking and noise. Well, I would say you can for sure impose reasonable requirements for parking and noise. I don't know that you can for lighting or smell or the number of dogs, because your ordinance doesn't reasonably anticipate them. I wouldn't mind if we stopped doing conditional use permits at all. But I don't know if you think this way. Jordan Cullimore, who's the lead attorney in our office, he disagrees with me. So I'm alone in this. I just think it's sort of like Simone Biles can do gymnastics, things the rest of us can't. So you can, but it's kind of like you got to know what you're doing or be prepared for fights. I mean, some of it, I hate it as a planner to be yelled at on like at big public meetings where we'd have to get a bigger forum and everyone would line up and yell at me. So some of it is I just wouldn't want to be yelled at if I were you guys. But that doesn't make it illegal. That just be prepared for the consequences. Okay, one of the things that they changed last year was they added completed non-compliant structures. And they added 2 different categories for how these might impact a proposed application. So a completed non-compliant structure, it's one that was built without a permit, without going through any process. They just went ahead and built it. If it's been there for 5 years or more, it doesn't pose a health, life, or safety concern, and it's unrelated to another application that's coming in, you can't require that they deal with it as part of it. So let's say that they want to come in and build a single-family home, but before they did that, they built a garage, and the garage wasn't permitted. You don't get to tell them you've got to clean up your garage or get your garage permitted before they get the main structure. My guess is, and I wasn't part of this, maybe someone, if Wilf was here, he could probably tell us. I'm guessing there was a particular person's property that fit this exactly, and that's why it got passed. But it does hamstring your ability to enforce things, particularly by withholding building permits. Yeah.
I'm just curious, because in law school, I was an intern for a city attorney's office. How many here have kind of heard it passed around that, well, we can't enforce something on a structure if it's been there for fill in the blank, 7 years? Or is that something that people have heard, that if something's been there a certain amount of time, we can't enforce against it? Raise of hands, anyone? Because that's essentially what this is doing, and I feel like I heard that before, and people would call our office and we tell them, that's not really a thing. A non-compliant structure it's a new violation every day it's there, right? You get to enforce it. But now this is a change in state law to now say, you know what, we are going to say that certain structures, after they've been there a certain amount of time, we're going to say, live with it, kind of thing.
Does anyone know where the prior understanding came from? Was it just a bunch of local ordinances had, or was it an old state law? Do you know? So it just took on a life of its own. Yeah. So, yes, please. We're going to talk about that half of it next. But yeah, this one is really just talking about if you already have an existing completed non-compliant structure, you can't withhold a second building permit because of that structure. But the second half of it is exactly what you're talking about. So here's the definition. A completed non-compliant structure is a building that was finished without obtaining necessary building permit, passing inspections, or securing a certificate of occupancy. Once it's been there 10 years, you can't require additional permitting, engineering, or inspections if it does, unless it poses a health, life, or safety concern. And I'm not sure how you figure out how it would have a health, life, or safety concern without asking that they go through the permitting process. That to me is the tricky one. And I think it makes it really hard once something's been there for 10 years to do anything about it. So I don't know, have these laws changed how you approach enforcement? Because I know before, I mean, when I was a city planner, we were busy enough without looking for trouble that we would just let things be until they became problems. But under this law, I think we'd be looking for them. So yeah, go ahead, and then you're nodding. But yeah. Yeah. Smart. I mean, I don't know what else you can do. Yeah. And you were nodding. Do you have a story to tell or just, yeah?
I do. It's kind of a surrounding question that we're starting to fill the gaps on. It's the term of legalization. I think with Salt Lake City's land use ordinance, there were terms of a 30-year term of a legalization process they could go through to quit if it's ambiguous or illegal construction.
Yeah.
My question is kind of, well, does that transition to use or is it only the structure itself? So you talked about SDRs.
Yeah.
SDR never got a business license or any other formal approval. How is it they can continue as established?
Great question. So I'm going to talk about the short-term rentals as opposed to the other, as the use versus the other, because I'm not familiar with that Salt Lake City law, although it makes sense that they would create that. So if I'm understanding correctly, if someone was had a short-term rental, but there was no business license or any sort of governmental process required, how would they establish that that had been created before the law went in effect? And the burden is on them. And it's going to be a really fact-specific inquiry. I assume things like Airbnb reviews or postings. Yeah, taxation maybe. I mean, my experience with things like that, if they go to court, they're really just fact-specific inquiries where people are coming and saying, okay, here's proof that I paid people to come clean it as an ADU. Here's the reviews I got. But the burden for legal non-conforming use, the burden is on the person saying that they had been doing that before the law went into place. The burden isn't on you to prove the negative. The burden is on them to establish it. Does that make sense? Yeah. And I mean, as far as buildings being there for 10 years, the burden would be on them as well. Now with Google Earth, it seems like it's really straightforward to go back and say for structures rather than uses that something existed at a certain time. But great comment, yeah.
But as far as what she's talking about now, I mean, we are just talking about structures, right? So we're not talking about uses. This doesn't change, legal non-conforming uses in any way, right?
Yeah, great point. Okay, so now I just kind of want to go through examples of where state law actually either gives you a floor or a ceiling. Because in general, you can do whatever you believe is in the best interest. There are certain categories they've decided that it's in the best interest of the state for them to step in, and gravel pits is one of them. Gravel pits, once the protection, I feel like every year, every other year just gets stronger and stronger and stronger. And I heard once, we deal a lot with UDOT, with eminent domain, and I was talking to the property director. I'm looking at Rick because he'll tell me. Someone who's high up in UDOT, and he was saying that the difference between, like when they're widening I-15 along like the point of the mountain where the prison used to be, if they can use a gravel pit that's local versus having to go like around from Tooele, which I think at the time that was like in 45 minutes, an hour away, it makes $1 million a mile difference in terms of how expensive the road is. Because I never really understood why gravel pits were talked about so much. But that, I don't know that I'm remembering those numbers correctly, but that made a lot of sense to me. But there's limitations on local regulations in 1741-402. And if you have questions about any of these later, feel free to call me. I'm happy to look up the citations and email them to you or talk about them more. I'll talk about land use law forever, but feel free to give us a call. But you can't prohibit, restrict, regulate, or otherwise limit a critical infrastructure materials operation. That's a nice word for gravel pits. And you need a gravel pit owner's permission to change their zoning. That sort of protection is unheard of anywhere else. Okay, the next thing that I want to talk about is design elements. You cannot regulate design elements on a single family residence or on a duplex, period. Later on, we'll talk about internal accessory dwelling units, and one of the concessions was when they made them legal virtually everywhere was that you could require that I forget the wording on it, but that they still look like a single family home. I would argue that this means you can't, because you can't regulate what a single family home or a duplex looks like. So yeah, please.
My understanding was that it was an overlay zone or part of the development agreement
So if it's a development agreement, then yes. If it's an overlay zone with a bonus density, then I would say yes. If it's something that they have agreed to, that there's something they got in value that has value as part of what they've given up, then yes, they can. Did everyone hear? So if it's in a development agreement or an overlay zone where they're opting into like a higher density or something else where they're gaining something of value, then you can regulate these design elements. Yeah.
Does AOA regulations override city ordinances?
So you can still, HOAs can still regulate what things look like. Yes, it's a private contract. The government can't get involved though. That's different than the government. That's a private contract among those who live there to say, we all want to have houses that look like such and such or whatever. So yeah, great questions. So the one that comes to my mind is internal accessory dwelling units. They said HOAs can't restrict those. I'm not aware of other changes to HOA, what they can and can't do. I'm happy to look things up though. It's tricky, right? And it's tricky. Yeah. Thanks for jumping in. I think this, well, I'll just say this. I think it's tough because so often what will make higher density more palatable is good design. And if you can't regulate the design of things, it makes the multifamily less palatable, which everyone is either clamoring for or against. I think it puts you in an awkward spot. So this one's a little bit older, so you probably aren't familiar, but internal accessory dwelling units. They're basically permitted throughout the state unless you're a city that has a really large university. So there's like 6 cities, 7 cities in the state, like Logan, Provo, Salt Lake City, Ogden, St. George, and Cedar City, I think. Those larger cities that have large universities can set aside a small portion of their community. There's a portion of their residential zones to not have internal accessory dwelling units. But for the rest of us, everyone can do an internal accessory dwelling unit. And that means you can't require a conditional use permit for one. That's something I've gotten a couple calls about. And they said, well, but if we tell them yes, then why can't we? Even after the condition, I said no. Okay, impact fees, this is, it's one I mentioned twice on accident earlier. Impact fees, I've reviewed a handful lately where the studies that back them up just aren't adequate. And it's unfortunate. I think some of them, they were older. One of them I'm reviewing was passed in 1995. So I'm sure there was a different approach and different standards and different laws in place. But if you're passing impact fees or you have impact fees, it might be worth a look to really make sure. I have an 8th grader at home. Does what you've prepared explain to an 8th grader why you're collecting the money and what the money is going to get spent on and what any exceptions are? And is it really, really clear, even if it were, let's say, a snarky 8th grader? But just another, you can't charge an impact fee for an internal accessory dwelling unit. You can't use impact fees. We can't charge a residential development for impact fees that are going to be used to buy a fire truck. And there are a lot of limits on how you approach impact fees in schools. If you're touching that one, then go look that up. You want to make sure you're not double dipping. So if you're requiring, say, a new development to build, let's say there's a collector road adjacent to it and you're having them build both sides of it. So we're not talking about project roads, you're talking about system roads. You got to look at if you're also charging them impact fees for roads then. Or if they've got parks that are going to be public parks, Even if they're private parks, I don't know. I'm arguing with myself as I'm speaking, but I was going to say if they provide parks, don't charge impact fees for parks, and I was deciding whether it would matter if they were public or private, and I'm not going to decide that here. But yeah, be really, really careful that your impact fees are really clear. I think we're kind of on an upward learning curve with what we need to pass impact fees. Okay, trails. You can't use eminent domain for a trail unless it's alongside a roadway. This, as someone who uses trails, this makes me really sad. As a personal level, as an ombudsman, I like understand the whys and support it. You can require trail connections as an exaction on development, and you can use impact fees to pay for trails. You just can't acquire the land for trails through eminent domain. So anything that you could negotiate at arm's length is fair. Okay, review fees. A municipality may not impose a fee for reviewing or approving plans that exceed the lesser of the actual cost of performing the plan review and 65% of the permit fee. We get calls, particularly in smaller communities that outsource their plan review, where they're being charged exorbitant amounts. For other things like that's for building permits, for other things like subdivision plats or grading plans, a municipality may not impose or collect a land application fee that exceeds the reasonable cost of processing the application. So it's the reasonable cost, it's not even the actual cost. Because if the reasonable cost is lower than the actual cost, if you're being overcharged by your consultants, or you're taking extra time, or I mean, I can foresee all sorts of just human reasons why things would get more expensive without even anyone trying to do anything wrong. You can't charge more than the reasonable cost to process an application. Okay, bonds. We've gotten tons of calls lately about bonds. You got to follow the laws. I feel like, too, this is something that's been changing a lot in the state law. You've got to establish inspection standards for infrastructure and landscaping bonds. It can't just be someone going out and saying, well, I think so, or not quite, or re-pour it. There's got to be set standards, objective standards. You can't require more than 100% the cost to finish an improvement plus the 10% administrative costs. And I've had cities say, well, I know these guys are going to do a horrific job. I know they're going to walk away. I know they're hurting for money and it's going to go bankrupt. We're going to be stuck with it. You have my sympathy completely, but unfortunately the law says you can only require 100% plus 10% of the administrative cost. And you've got to establish a system for the partial release of the improvement completion assurance. So you've got to have a system in place. They've finished the sidewalks, give them their sidewalk money back, or curb gutter sidewalk. You've got to figure out a way. You've got to have a system in place where they can get those repaid. And you've got to have 2 forms of completion assurance, and you can't require bonding for private improvements. And again, I understand the awkward spot it can put you in if someone's going to build private roads and you think they're going to walk away before they're really finished. You're inheriting a mess because those are going to be your citizens even if they're private roads, but state law binds you there.
So I mean, as of, was it yesterday, right, that all the new bills went into effect? Right. Yeah, so this legislative session, there was a lot of work added to the bonds, and one of those is that you have to put that money into an interest-bearing account and you return the interest to the applicant, right?
Thanks for that. Okay, certificates of occupancy. You must issue a certificate of occupancy if the applicant has met all requirements essential for public health, public safety, and general welfare of the occupants. As an attorney, that word essential, it triggers sort of very heightened scrutiny. It's got to really be essential, like the roof is going to cave in. we'll talk, it comes up again later, but lack of asphalt, lack of sidewalk, lack of, walk up to the house. It's not enough. It's got to be, you can only withhold certificates of occupancy if it's essential for public health, public safety, and general welfare. Their septic system doesn't work, something. Yeah, Tom.
So the state modified it as separate section this past legislative session. Are you going to get to that? Yes.
So I believe that, and I know a lot from 10,000 feet. You guys are the ones working with it. But I read this 109A802 that says, except for as provided in the following sections, a municipality may enforce the building municipality's ordinance by withholding a building permit or certificate of occupancy. And I went and looked and said, okay, which one came first? And no, this one's new, so it's clearly intentional. I still would look at this and the last one and say, okay, tie goes to the property owner. If there's any ambiguity, or if there's two ways that a reasonable person can read this, I would say this one would override that one, even though the other one is new.
Sorry, let me make sure I'm understanding the question, right? So we're saying that, go back to the other one where it says, except for subsection 3, you can, basically withhold, you can enforce your ordinances by withholding occupancy. So the exception of that is, go back to the other one. Basically, what you can't do is, or what it's saying is, the reasons that you could do that are things that are essential to public health, public safety, and general welfare, right? So you couldn't, yeah. So I wouldn't see these as conflicting, right? One's a qualifier of the other, right? But
so what would you say? Can you withhold a certificate of occupancy
for essential items, right? Not for non-essential items, right?
you would consider essential items like
What it said, right? Health, safety, welfare, right? Or like go back to, what's the language?
these words not needed, which you're not supposed to read something in a way like you're supposed to give each word meaning, and so each word were included on purpose and has a meaning.
Right. In other words, the example I would think of that we've gotten calls about before, right, is we're not going to be holding with certificate of occupancy because of unfinished landscaping, right? Or something that's really has nothing to do with the occupation of the building, right? Or the safety of those in the building, right?
So how do you reconcile that with this language, though?
Well, that's exactly what it's saying, right? It says you can withhold occupancy for these reasons, going back to the other one, right?
So they're completely different. This is 109A802, and the other one's 109A509.
Mm-hmm.
They're not related at all. I think this is where you've got different legislatures doing different things, responding to different things, and until we have a court tell us, I don't know. I'm hoping it's something the land use task force will help them make a decision on.
Well, yeah, because 10.3A says that you may not deny an applicant a building permit or a CFO because the applicant has not completed an infrastructure improvement, unless the infrastructure improvement is essential to meet the requirements of the issue of a building permit or CFO under the state fire code,
Mm-hmm.
fire code, or for which the municipality has accepted as completion improvement assurance.
Can you speak into the mic?
Oh, sure. I usually can just yell. Okay, so looking at the other slide that she had that said, unless in subsection, except as provided in subsection 3. Subsection 3 says a municipality may not deny an applicant a building permit or CFO because the applicant has not completed an infrastructure improvement that, one, unless the infrastructure improvement is essential to meet the requirements for the issuance of a building permit or certificate of occupancy under the State Construction and Fire Code Act, and for which the municipality has accepted an improvement completion assurance for public landscaping improvements as defined in 10.9A, an infrastructure development, improvement for the development.
They're all saying the same thing, right? They're saying you can do this for things that are essential, right? For fire code, and for the things that accepted landscape.
So you think it's just clarifying what is essential? I don't like the way they're written in opposite ways.
Yeah, no one said the legislature's doing a great job in how it's worded.
I wasn't going that. I feel like I need grace. I expect to offer grace.
But it is changing what she just read was some of the new changes that just went into effect.
Yeah, yesterday.
That basically further define some of those things that are essential.
I wish it wasn't worded. I wish this part wasn't worded the way it was. Okay, asphalt. You can't require that asphalt be installed prior to a certificate of occupancy. That's from 15A 5205.6. And that's if an improvement completion assurance has been posted. You can't require asphalt. And I knew before you couldn't require it before building permits. This was new for me to have found. Maybe it's been around for a long time and I do think it puts cities in an awkward position where I think when I was a planner, it was a whole lot easier to withhold their certificate of occupancy until everything had been done. It was the biggest or else. It was the biggest sort of way to make sure that things were clean. I think you guys are really hampered now, and a lot of things are left to enforcement instead of being able to just withhold certificates of occupancy, which makes things harder, I think. Okay, billboards. There are a total of 99 instances of the word billboard in LUDMA. If you're dealing with a billboard, you really want to go read it. But upgrading billboards straight out is legal. To me, it's like the gravel pit carve out. It's really interesting to me just how preferential this is. But billboards are a really strong lobby in the state. Food trucks. Yeah, go ahead. Can anyone else? I know that upgrading billboards is legal, and I know that I typed that in because I read it. I didn't go back and read the case law to see, does that mean you can make it bigger? Does that mean you can make it taller? Does that mean you can make it electric? I don't know. I'd be happy to research that. But has anyone else gone down that rabbit hole? You have?
We currently have a billboard company that says state code allows them to move their billboard. It's in one location, it's old and raggedy, and they haven't updated it in a while. They want to take it down and move it to a better location. And they say we can't, or that municipalities can't prevent the move.
That's my understanding as well. Is that it's within a certain distance, though, right? I'm looking at the crowd, but yeah, state law does protect them. That sounds right. Yeah, like a mile.
That's if they're getting displaced, right? So
If they're not, it's a choice.
okay, so that's different. I don't know if there's a separate provision. The provision that I'm familiar with that I'm thinking of, right, is that if they're basically displaced by eminent domain, so if I-15 is getting widened and they take a billboard, then state law kind of gives very specific rules about they can relocate that sign. It used to be in a mile, but actually, again, another change that just happened this session was kind of lax some of those requirements, so they can basically relocate anywhere within the same city or even another city if they have the agreement of the other city.
They've lost their lease. The landowner has decided not to renew it.
Okay.
Is the billboard staying there? Is the landowner keeping the billboard?
That's a good question. I don't believe so. I believe he wants them to take it down so he can do something else with that property. And so they're saying because they've lost their lease, they must move it. They can move it within a mile.
Yeah, okay, because yeah, I mean, I think there is, the short answer, right, is that billboards have their own special rules because they have a very active lobby and, yeah, okay. Moving on.
I don't know that exact answer. But it's a,
Part is they want to put it right next to somebody's ADU, which would make them outside setbacks, et cetera, et cetera. You're going to be hearing
She's going to call us. That's the short version. If you missed anything, she's going to call us. Okay, food trucks. You can't regulate the size of a mobile business. You can't require a criminal background check on the operator unless it's an ice cream truck. And you can't require demonstration of how food truck will comply with the land use or zoning ordinances at the business license. Okay, short-term rentals. As a state, we're sort of really maybe as a nation, as the world, trying to wrestle with how to put bounds on short-term rentals. But you can prohibit them from internal accessory dwelling units. You can prohibit them outright. You can allow them everywhere. You can do the opposite as well. You can require business licenses, and you can require a manager within a certain reasonable distance. You can now use the advertisement and reviews on the website as evidence of use. I think it's just one element of evidence, though. It can't be the only thing. What's that? Right. And do you know what something else would be? She's saying you can't just rely on the website. You need something else.
Yeah, you can. So there's sites for STR investors that will tell you what ADUs are in your market and whether or not it's beneficial for you to open an ADU. And our short-term rental, sorry. And so I think it's called, I can't remember. There's a bunch of different ones. And they basically are for investors or to check out the market. And our attorney, and from when I've talked to Jared Tingy and all those guys, that is okay because it's not advertising the rentals. So you can, a lot of them are free, or you can pay a small fee for your area or whatever. But once you go in and see where they are, then you can verify them on an Airbnb or Vrbo site.
That makes sense, thanks. Well, and I thought too, people had relied on talking to neighbors, or once you know what's there, you can go drive by or things like that. Yes? Is the guy from Hurricane here? There's a guy from Hurricane does a really good job of it. I really liked his presentation last year. I've heard 10 miles, and I've heard 10 miles is really reasonable. When you're passing that ordinance, you want to have evidence on the record to support why it is whatever it is that you're establishing it to be, whether it's expected time for them to be able to get there, or safety, or social concerns where there'd be social pressure. You just need reasons to support your decision when you pass that ordinance. I'm not aware of a court speaking to what some magical amount being too short or too long. And remember, I've mentioned this several times, legal non-conforming uses. So I suggest getting your ordinances in place. Even if you're not sure what you want, get something on the books. Okay, I want to we have just 5 more minutes. I'd like to talk about the difference between moratoria and the pending ordinance doctrine. Moratoria, I think, is one of the most overused or not used correctly tools. I think cities aren't getting sued about it because it has an automatic stop in 6 months, but I think it's kind of, it makes me uncomfortable. But a moratoria, it's in the code, it's called a temporary land use regulation. It's a pause on processing land use applications. It can last up to 6 months. The council's got to find a compelling countervailing public interest, or the area isn't regulated yet, and it pauses applications already received, and it's an exception to the vested right, and it's retroactively applied. So let's say that, I would say a valid use of it, remember when those homes started sliding down the mountain, I think in Draper? I would say if you had a building permit that was in place that met all the requirements of your sensitive lands overlay or whatever for that area, and those houses started to slip, I would say that passing a temporary land use regulation, a 6-month moratoria for you to figure out what your ordinances needed to be to make people safe, is the anticipated use of that. That'd be a good use of it. You would need to find a compelling countervailing public interest, and even if you had applications in play, even if you'd probably issued a permit perhaps, you could put a stop on them. So it's an exception to that really strong vested rights. The support for moratoria, it's really, really hard. You've got a high jumper going over the bar. The compelling countervailing public interest, it's got to be an emergency situation that you can't foresee. I would say like the homes falling down the mountain, I would say you have an earthquake and it, disturbs your sewage treatment plant. You discover something unusual with your, water, that your water treatment plant isn't doing its job, so you don't have clean water for people. Something that's unforeseen, that's truly an emergency. It's got to be a substantial risk. Like the Palisades fire in California, I would say would be a compelling countervailing public interest. And the reason that the bar is so high is you're messing with people's vested rights. That people bought land, they paid engineers to do work, they've brought plans to you, and they've spent a lot of money, and now all of a sudden you're changing the rules. It's got to be a really high bar. The second way you can do things is the pending ordinance doctrine. It's also a pause on land use applications. It's up to 6 months long, and it applies to all applications received after zoning change is formally initiated. The difference here is what triggers it isn't a finding of compelling countervailing public interest. The difference is you go about your normal way of advertising that you're going to change things. So let's say I keep bringing up short-term rentals. Let's say you really realize that they're becoming a problem or that they need to be addressed. So you put it on the agenda for your next public hearing before your Planning and Zoning Commission that you're going to discuss short-term rentals and ways of treating it. You don't have to find a compelling countervailing public interest, and it pauses applications that come in after that deadline. They're on notice once you hold that, once the meeting gets noticed, they're on notice that you're changing the rules, so the new rules would apply to them. You can have up to 6 months to put your new rules in place. After that 6-month window, you got to process what you have and apply the old rules if you don't get new ones done. It's a really low bar. With a moratoria, it's a really high bar, compelling countervailing public interest. I think it's got to be sort of an emergency unforeseen situation. Pending ordinance doctrine, it's a really, really low bar. It's the same you have for all legislative decisions. It will be upheld if reasonably debatable that the decision promotes the general welfare. And it's really just a timing issue. In the moratoria where the houses are falling down the mountain, even someone who'd applied for a building permit and in theory vested under the rules in place, it's because it's such an emergency, nope, you can apply the new rules to them. Under this, if you've already received something and then you go to notice that you're changing your ordinance, they still get the old rules. So it's a minor change. Sorry, spam is going to my watch and it's makes my hearing aids hear my phone instead of y'all. Yeah. Correct. It's just notice. It's whatever way you normally give notice that you're looking at something. So it's if you post your agenda on the public website 3 days before, or you decide to post it 14 days before, that's when it triggers. I recommend this over the moratoria, if at all possible. I think we're out of time. Thank you all. I appreciate everyone's participation and jumping in with the answers and questions. I appreciate it. You guys are a great group. Thanks for what you do.